Welcome to EUPrivacyForAll, Session 20 on GDPR, Article 16, Right to Rectification. The final numbering retained regarding the right to rectification is Article 16. It lays down that the data subject shall have the right to obtain from the controller, without undue delay, the rectification of inaccurate personal data concerning him or her. Taking into account the purposes of the processing, the data subject will also have the right to have incomplete personal data completed, including by means of providing a supplementary statement. Article 19 on the notification obligation regarding rectification, erasure or restriction also provides that the controller had the obligation to communicate any rectification to each recipient to whom the personal data have been disclosed, unless this proves impossible or involves disproportionate effort. The controller will also have to inform the data subject if the data subject requests this. Recital 73 lays down that restrictions concerning specific principles and concerning the rights of rectification, notably, may be imposed by union or member state law. Those restrictions should be in accordance with requirements set in the Charter of the European Union. It is also reminded in Recital 156, and Article 13.2b and 14.2c once again recall that the controllers have the obligation to inform data subject about the existence of this right. Recital 39 provides that, in order to ensure that the personal data are not kept longer than necessary, time limits should be established by the controller for erasure or for a periodic review. Recital 59 stresses that modalities should be provided for facilitating the exercise of this right, and Article 58.2g lays down that each supervisory authority have corrective power regarding this right. The Directive 95/46 lays down a right to rectification. In Article 12b and c, it is reminded that the right to obtain from the controller the rectification of data is possible and mandatory if it does not comply with the provisions of the directive. There is also an obligation to notify to third parties to whom the data have been disclosed of any rectification of data, unless this proves impossible or involves a disproportionate effort. What should accountable data controllers get prepared for? First, they should guarantee data subjects the exercise of a right to obtain the rectification of personal data without any kind of undue delay whenever data is inaccurate. They should provide the data subjects with the right to obtain completion of incomplete personal data, including by means of providing a supplementary statement. They should ensure fair information of data subjects, set time limits for data retention, facilitate the exercise of data subjects' rights, and communicate any rectification to each recipient to whom the data have been disclosed, unless this proves impossible or involves disproportionate effort. The controller shall also inform the data subject about those recipients if the data subject requests this. They should bear in mind that member states can provide restrictions, derogations, or specifications to this right, and anticipate the fact that each supervisory authority has the powers to order rectification of data. So, EDPB, European Data Protection Board guidance on supplementary statement, undue delay, and what proves impossible or involves disproportionate efforts will be particularly interesting.